Dear students, GPS CLAT Academy at Gyanodaya, a senior secondary school at Sikar, supports its students in their CLAT preparation. We have started a lecture series which will be delivered to you on a daily basis on YouTube.
The article basically provides uh, this is an article which is an important article. Pre-opposition patents, pre-opposition to the grant of patent. This provision is not existent elsewhere, but it is existent in India. The author says this was causing delays, and hence the government has decided to dilute the provisions as regards pre-opposition to the grant of patent. Means opposition means you can object that this patent should not be granted. Now pre-opposition is diluted, but it is not done away with. They have said that they have made it discretionary, worthwhile created pre-opposition patents can be entertained, but then you have to pay a fee for it in order to discourage people from uh, unnecessarily filing patent oppositions. Now, the the patent is granted in order to uh, promote invention, right? So the idea of behind a patent is that you have 20 years to work the patent. Now, in that 20 years, you can have monopoly in production, monopoly in issuing sub licenses to the other companies. You can give your patent for exploitation, you can sell it to the company, or you can enter into royalty payments. You must, you are already familiar with Alfred Nobel, who invented the dynamite, and it was so useful in for destructive and non-destructive purposes. Basically, that the corpus of the amount received from royalties in working the patent, that is sufficient to fund the Nobel Prize, which is the largest, which has the largest corpus among the prizes in the world. So you can understand the kind of money Alfred Nobel basically did uh, uh, gave his entire wealth that he created out of the invention of dynamite. He created that into an endowment, and he funded the Nobel Prize out of it. And still, it is continuing with the interest of the money that the wealth that was generated at that time. The institution of Nobel Prize is running. So you can understand what kind of implication a patent can have. But then you can also understand what can be the problem if people start holding the patents. Actually, you can hold a patent by not working it. Somebody else might have invented the same thing at the same time, but he will not be allowed to exploit the the patent, the invention, and the person who has a pre-patent, prior patent, he will be allowed to exploit the patent, and for a 20-year period, he will the subsequent person who who made the same invention will not be allowed to exploit that patent. So it creates the problems also. And here in this case, the pre-grant opposition to grant of patent was creating a problem, and they have done away with all that. And in fact, the system is such that the the patent has to be after the grant, the patent has to be worked. How do you ensure that the patent is worked? First, the patent is granted, then you have a form 27 which has to be filled. Form 27 has to be filled, and in that form 27, various information, various pieces of information have to be provided to the government. How much you have worked the patent, how much you have, what is the quantum of production that has been undertaken. If you have not undertaken the production, why you have not undertaken the production. So there are a number of parameters already included in Form 27, which for which the information has to be provided. Now, if you are not able to work the patent, then the government has the power to compulsorily uh, uh, license the patent to somebody else who can use it. Now that is compulsory licensing of the patent. Compulsory licensing of the patent is also used. These provisions are also used when you have the when you have a situation wherein there is a public emergency. For example, an emergency of the like of COVID-19 is there, and patented drugs are required. The government feels that there is a public emergency, and for public use, they will have to grant licenses to a large number of people. Then those provisions are also there in order to protect the public interest. Now, in this case, compulsory licensing can be granted, means compulsorily licenses can be issued to another person in order to exploit the patent because the original patentee was not in a position to exploit the patent when it was required in public interest. If for 3 years you have not used the patent, and then number one, number two, if the patent, if after grant of compulsory licensing also the exploitation of patent has not taken place, then too the proceedings for revocation of patent can be taken. It means cancellation of patent can be done if the patent manufacture pursuant to grant of the patent does not take place. So then there is this issue of evergreening of patents. Evergreening of patent means suppose you have been granted a patent in a particular say you have a patent in say what example, a hypothetical example I take. Suppose you have a patent for a suppose you have a patent for a bicycle. Let me take a hypothetical example. Though bicycle is not an apt example. Why? Because it is already in the public domain. Therefore, no patent, no invention is there. No, nothing new is there. There must be novelty. There is no novelty in it. Therefore, it can't be. But let us take a hypothetical example. Now, what you do is that you hold the patent for bicycle. Now you can manufacture the bicycle. You can license the production of bicycle to somebody else. You can take all these steps. Now, after 20 years, you earn the royalties for bicycle, and after 20 years, you come to the patent office and say that look, I have added two wheels to the bicycle on the side so that children can ride it. So the question arises whether it is a case of evergreening of patents. It can be opposed. It can be opposed on the ground that this is evergreening of patents, means they have done a very small incremental addition, and that incremental addition does not qualify for being conferred another period of 20 years. That kind of invention doesn't have that much utility that another renewal must take place for 20 years. That is called evergreening of patents. Make some small incremental addition in the original patent and claim another 20 years, claim the right for exploitation of the patent for another 20 years. That is evergreening of patents. That is not the policy of law. They don't want evergreening of patents. They don't want hoarding of patents. Nevertheless, there are provisions in the law which prevent hoarding of patents because there is a requirement for submission of returns on how the patents have worked. And if those patents have not worked, then their use or their grant may be taken up for cancellation. And then what are the grounds on which a patent, after the patent application has been put into the public domain, how it can be registered? It can basically be registered on a number of grounds, such as if the patent is already available in the public domain, if the patent has been obtained wrongfully, if there was prior publication, if there was prior claim of somebody else, then it doesn't have any inventive steps. All these are the steps basically when a patent application can be basically a patent application can be allowed. Patent opposition can be allowed on these grounds. So this is basically the article talking about. Now let us take up the questions. Please come to question number 71. Whoever has marked it incorrect, he will be the person who will taking up the question, right? So that doubts disappear in a more efficient way. Yes. So section 25 basically, just have a look at your screen. Section 25 basically provides for the following grounds. One is invention has been wrong or wrongfully obtained. One is prior publication. One is prior claiming. Then you have publicly known or used in India before filing. Then obviousness does not involve any inventive step. Non-patentable subject matter as per the Act, insufficient disclosures, and failure to disclose information under Section 8 of the Act. In case of convention application, was not filed within 12 months. So, non-disclosure or wrongful disclosure of source or geographical origin, biological. So, there are a number of grounds on which you can basically oppose patent. And here, what they are asking is how the opposition can be on which ground. Prior publication is a ground which is listed there. Invention obtained wrongfully is also a ground which is listed there. Invention has been sold, means it is already available in the public domain. That is also available there. No disclosure of source of this is also available there. So all of them are valid grounds. Okay. Chaliye. Please come to the next paragraph. So this article basically talks about the royalties and the legal implication of imposition of a royalty. And the article also uh, clarifies various things about the mining sector. Mining sector is basically a very capital intensive sector, and the way in which the whole system works is that you have to pay the state government will basically uh, issue a concession, a contract which is called a concession contract in favor of the person who has been selected for grant of the concession. Um, its taxes are to be, if you see the article, there is somewhere it is mentioned that entry 50 of the state list empowers states to levy taxes. If you can see that here. Entry 50 empowers the states to levy taxes on mineral rights, excludes mining royalties from this definition, right? So, entry 50 of the state list means it is in the list 2. In the list 2, the power to take executive action as well as legislative action is traceable to the state government. That power is not traceable to the union government. That is already known to you. Now, the entry 50 itself says that mining royalties are excluded. Once mining royalties are excluded, then where do they go? They go to the union. Because the we have a union heavy uh, uh, categorization of legislative and executive powers in the seventh schedule in terms of list 1, list 2, list 3. And the number of entries granted to the union to exercise legislative as well as executive powers is far numerous compared to those granted to the states or compared to those enumerated in the concurrent list where the union and the states both have the powers to make laws. So therefore, royalties, the court has clarified that entry 50 is very clear. It says that royalties are not included in this, and therefore royalties basically will the rate of royalties, determination of the rate of royalties will lie with the with the union with the union government. And the article also clarifies that now under the Mines and Minerals Development and Regulation Act, the government has taken up the, the critical minerals. There is so much uh, there is so much importance these days being attached to the critical minerals, and out of these critical minerals, there are 24 of them which the state government has taken up for auctioning. And for auctioning, generally it is the union government which has the power to to determine the rates. And Who will collect the royalties? The royalties may actually be collected by the state governments, but the auction will have to be conducted by the union government, as per the bifurcation of the powers that are given in the entry 50. So, mining the framework or the legislative design that is given in the act is basically a concession is issued. After the issue of concession, the the rent has to be paid by the concessionaire even before that kind of rent, and then you have the the system of taxation, which is different. Royalty is different. Taxation is different. Dead rent is different. These are several concepts which have been utilized in the passage. Dead rent means once you have been given the land for mining purposes, you will have to pay the rent whether or not you commence the operations. So economic rent will have to be paid. Concessionaire will have to pay to the government, and then when you start when the mining operations start and the the profitability comes in, then you will have to share a particular percentage of the profits with the government in the form of royalties, right? And the court has also clarified that the royalty is separate from tax, whereas royalty is contractual. The tax is not contractual. The royalty you is comes into existence because you have been given a concession. But tax does not depend on the issue of a contract to you. The tax is imposed pursuant to the sovereign powers of the government, and therefore, uh, since mineral royalty on the minerals is not the same as tax on minerals, therefore, union government is held to have the powers to um, uh, levy the imposition of the royalties. Right? This is what the article basically talks about. Now, please quickly come to the questions. The dispute arises where the state government attempts to levy additional charges on a mining company under state's fiscal powers. So they are actually using their powers under entry 50. If you see what they are saying under entry 50, I'll just draw your attention to this. For entry 50, just one second. Let me pull out entry 50, which I have sent. Empowered state levy taxes on mineral rights. So they are not imposing royalties. They are under fiscal powers. Fiscal powers are in entry 50. Therefore, they can do it. Is that okay? Do you understand that? Yes. Basically, it says that company enters into an agreement with the state government. So it is contractual, right? Company pays a certain, the moment you enter into an agreement, it becomes a contract. Company pays a certain percentage of revenues to the government from time to time. There are provisions for enhancement of company's payment liability. The government revises the levy. Company raises a protest on the ground that levy is not justifiable and the same has been imposed pursuant to government regulations. So it says um, uh, the revision is legally invalid. So what is the ground for that? This is an agreement between the state and the company, mining company, and the agreement is revised, right? So what can be the objection against that? This is a contractual agreement between the two, right? It can be rent agreement can always be there. It may not be. Company pays a certain percentage of revenues to the government from time to time. Now, this certain percentage of revenues to the government from time to time can be in terms of an agreement, contractual agreement also. There are certain provisions for enhancement of payment liability. Government revises the levy. Company raises a protest on levy is not justified, says pursuant to government regulations. Now, this is not pursuant to government regulations. This is pursuant to contract between the mining company and the government, right? And if it is merely a matter of contract, then surely the levy can be enhanced. Is that clear? Is that okay? If it is only a matter of contract, then the levy can be, moreover, if the levy is enhanced, you don't have a right to protest against the same who has taken an auction for critical minerals. Policy of the government says it is only the union which is going to do it. The mining firm takes an objection. So if the mining firm takes an objection, the objection will have to be allowed and the auction has to be set aside. Why? Because it is the union government which has taken up the auction under this thing, right? चलिए आगे. Next question. Mineral prices independently you can't set. That is not possible, right? You have to go according to the rates fixed by the union government. And in case of critical minerals, you can't even hold the auction. Royalty rates will have to be set. This is a matter of setting the prices. You know, it is not a matter of imposing a tax. They are putting the prices. So set the mineral prices independently. Pricing of the minerals in terms of what is the passage saying for pricing of the minerals? Is it saying anything? Court also emphasized on here it is. Emphasize ensuring a certain level of uniformity in mineral prices. Therefore, royalty rates are fixed by the central government and the revenue is collected by the states. So, royalty rates are fixed by the central government. Pricing, uniformity in pricing. All right, please go ahead. Come to the next one. So, the article basically talks about a recent ruling of the Supreme Court, wherein the court has overturned a 1968 judgment, which was in Aziz Basha's case. Basically, in the original case, it was held by the court that a minority institution which has come into existence through the operation of a statute, an institution which has come into existence through the operation of a law, is not and cannot be considered a minority institution. That ruling has been overruled, and instead it has been held that it doesn't matter whether the statutory intervention had brought about the institution in existence, and what really matters is that the institution has been established by the minority community, and it has been established for the protection of its language, script, or culture, or even for giving general education to the members of the minority community. After having established the minority institution, the minorities must have had a continuous oversight. But out of the two tests, the test of establishment was found to be more predominant, and administration would naturally follow from the establishment of the university. So this is a positive mark, positive development in the realm of minority rights jurisprudence in the country, and this judgment strengthens the minority jurisprudence under Articles 29 and also under Article 30 of the Constitution. And basically here the petition originated in the Allahabad High Court, and in the Allahabad High Court the 50% reservation for Muslims was contested, and on the ground, and the Allahabad High Court basically stated that since in Aziz Basha's case, the IMU, Aligarh Muslim University, was held not to be a minority institution, and therefore the 50% reservation of Muslims for Muslims was not proper. The Allahabad High Court was of the view that since Aziz Basha's case is a governing precedent, therefore they are bound to follow the judgment of the Apex Court of 1968 in Aziz Basha's case. And when the matter came to the Supreme Court, the matter was referred to a larger bench, and the question was questioned on whether statutory intervention would take away the minority character of an institution was once again placed before the court. And this time the court has ruled in favor of the minority character of the institution, and the reasoning which has been given by the court relies heavily on the natural rights jurisprudence, natural rights philosophy, The court has stated that in in Article 13 of the Constitution, basically the rights which have been recognized as after the Constitution came into existence. But then the court states that these rights are inherent in individuals, and there is a difference between the Part 3 rights actually creating the rights of individuals. It is not like this. It is like the Part 3 rights merely recognizing the rights, or recognizing the rights which are already inherent in individuals, in human beings, because they are human beings, because human beings have a dignity and they are born with the dignity. They are innate and inalienable rights. Therefore, even statute was statute founding the AMU was of 1920 vintage, and when at that time the British rule was there, and at that time the fundamental rights chapter was not there in the Constitution. The court held that it makes no difference because Constitution has not created the fundamental rights. Constitution has only recognized the fundamental rights. Fundamental rights are inherent in individuals. Therefore, even if the Constitution Part 3, Article 13 has basically taken off in a prospective way, but the rights of individuals cannot be denied. And on these grounds, the court also relied on the K.S. Puttaswamy's case, in which this philosophy has been exposited by the court. So this is, and then coming to the legal parts of it, it is interesting that the court has followed the doctrine of precedent. Doctrine of precedent basically means that whatever has been decided uh, becomes a precedent for a subsequent case. In an earlier case, whatever ruling has been given, and that ruling has been given by a bench of larger strength, then that ruling becomes a precedent and it has to be followed unless the ruling is set aside. And if there are serious doubts about the validity of the previous ruling, as has arisen in the Aziz Basha's case, then in that case, the proper course of action is to play the concerned bench will place the matter before the Chief Justice, who will constitute a larger bench to examine the question which has arisen and the facts and circumstances in which the earlier uh, earlier judgment which has been given is to be reviewed. So this and then another aspect is the doctrine of stare decisis, which means that the court's rulings, the Supreme Court itself is not bound by its own judgments. It is not bound. It can, in an appropriate case, it can deviate from the judgments or law that it has laid down. So this ensures that continuous development of the law takes place. But stare decisis won't apply in case the doctrine of precedence applies. For example, there is a judgment by a coordinate bench, means of equal strength, or there is a judgment by a larger bench. Then in that case, doctrine of precedence is binding, and you have to decide the case in the light of principles laid down in the larger bench decision. But in case there is a doubt, then you can place the matter, the concerned bench can refer the matter to the Chief Justice, and under the doctrine of stare decisis, the judgment can be revisited. Is that clear to you? So, Aligarh Muslim University introduced a 50% reservation for Muslims, which was challenged. The university relied on the 1981 amendment to defend the reservation, but the court rejected its argument, citing Aziz Basha. Based on this, which legal principle was crucial and determinant? So, it was doctrine of precedence. So, doctrine of stare decisis, as I already told you, doctrine of stare decisis means the Supreme Court itself is not bound by its own decisions. Though the decisions of a larger bench will continue to bind the decision of a lower bench. Right? Bench strength is very important. If three judges bench decision is contrary, then it is binding on two judges bench decision. And if five judges bench decision is there, then it is binding on three judge bench decision, and also on five judge bench decision. Benches are also bound; they can't work at cross purposes. And if there are doubts, even if the doubt is expressed about a nine judge bench decision of the Supreme Court, but the doubt is expressed by a smaller bench, and the matter can be placed before the Chief Justice, who will constitute a larger bench for consideration. Now, doctrine of precedent basically means that whatever has been decided earlier has to be followed. Doctrine of ratio decidendi. Ratio decidendi means the essential facts and the ruling given in those facts, that becomes the law laid down. So that is ratio decidendi. What is the ratio of a case? That means what is the law laid down in the case. So that is ratio decidendi. Obviously, ratio decidendi has no application here. There is another one, another doctrine, which is the doctrine of arbiter dicta, which is the last one. Basically, doctrine of arbiter dicta is an observation of the court on a point of law. And the observation on the court on the point of law may also be binding. So, but then observation of the court on a point of law of the Supreme Court is binding. Always remember, even the arbiter dicta of Supreme Court is binding on all other courts. Yeah, no court can ignore the Supreme Court's arbiter dicta also, right? So we have to keep that in mind. And let's go to the next question. So basically, yeah. So basically, this article talks about a very important aspect of our society. Some tribes are notified tribes. The British, came up with the theory of martial art, martial communities. Remember that? And among the martial communities were identified the Sikhs, the Marathas, and so on and so forth. So these are a myth was created that these are the fighting communities. The fighting skills may not be innate; they are learned, right? So that martial community, martial races, these are the martial races, and based on the martial races concept, the recruitment in the British Army used to take place, primarily from among the various castes. Now that was a highly disturbing kind of theory. Another disturbing kind of theory is this criminal tribes. That is another one. This is also a law of British vintage. The problem with the what we call it, the tribes, or the problem with the administration is that movement of the tribes from place to place makes the administration suspicious. You will notice that the British tried their level best to settle the tribes at one place. And while the British were colonizing India, they had made so many efforts in this direction, but not always their efforts were met with success. And there was a systemic prejudice against these tribes, and they were called as the criminal tribes. They were that kind of. This got percolated in our legal system also at independence. And finally, in 2024, the apex got, of course, earlier also, as the article itself mentions, there have been cases where the Supreme Court has laid down guidelines for declaration of people as of habitual offenders. There have been previous judgments also, Rakesh Kumar's case and Amanatullah Khan's case. The Supreme Court says that the system of creating history sheets has to conform to the guidelines mentioned in those cases. But now the Supreme Court has come up with a ruling which does away with the entry of notified tribes in the criminal manuals, the jail manuals, and This is a very heartening development that the dignity of the tribes is restored, and not everybody is painted with the same brush in a arbitrary fashion, in an all-encompassing fashion. That is heartening. The the court has gone one step further, and the court has also done away with the system of noting the antecedents or the caste origin of the tribe and all that. All those caste insignia of the tribe and all those is also gone. Now, the author has a problem with this kind of this part of the ruling. He says that this data was very important in basically assessing as to what is the what should be the policy and uncovering the discrimination which could be inbuilt in the system. Now, with the abolition of the caste record of an individual, it has become very difficult to populate data, and in the absence of data, policy formulation is not possible. In the absence of data, the correct positions may not be possible to be taken. So that part of the ruling is objected. The court has also reiterated that in what circumstances and to what extent the habitual offenders can be classified. For example, the court says you have to have something like 15 offenses, and they should be current for the last 10 years. And they, then only you can be put into the list of the habitual offenders. Otherwise, you can't be put into that list. Then the court also goes on to say that mere passive participation in some rally or in some other democratic process will not invite this kind of classification. So, in any case, in Putaswamy's case, the court has upheld the privacy, the right to privacy. Therefore, this kind of discrimination is also hit by the privacy, which the court has held to be originating from the 19th century theorists of natural law, which we have seen in the previous article also. So, in the light of the Putaswamy's ruling also, this kind of classification has become suspect, and the court has accordingly done away with the habitual offenders classification, and for the tribes, the automatic listing into based on a person's tribal status. So that has been done away. This is what the article talks about. It is one of the better judgments of the Supreme Court. Now let us come to the questions. The court has not discussed this, right? Court has not discussed as to why they are deleting these recordings, right? So we can't say this is correct. And second is the court directed the deletion to curb institutional discrimination. Maybe, but there is nothing in the judgment which says this. They have straightaway done away with as per the article. The court passed the direction in order to render complete justice. Now this is not here, neither here nor there. Now this is the court's directions have created a situation of policy vacuum. This is correct. It is borne by the arguments that now the policy formulation is not possible. In the absence of data, how will you formulate the policy? Not possible. Because data helps you in policy formulation in the sense that data gives you insight on what is missing, where we are going wrong. How many people from the tribal criminal, so-called criminal tribes have been included, and how many people from the non-criminal tribes have been included? Whether there is an over-inclusion, we will not be able to tell, right? And what are the circumstances in which the people have been included in this thing? This we will not be able to correlate with the caste status or tribal status of an individual. Therefore, it has created a policy vacuum. Court's directions need to be modified, definitely. Once a policy vacuum situation is created, B follows automatically, or court's directions need modification. All right. Now, please come to question number. Next one is question number 90, I guess, which is 100% correct. So we need to bother. Now, please let us come to logical reasoning quickly. because we have to finish this paper today. We are finishing at the rate of 2 days and one paper, 2 days, which is not a very happy rate. We should be finishing more. All right, let us. Now there are only 25 minutes left and 4 articles to quickly take it up. Don't take so long. Yes, so it's a very interesting article, and you know the goals of the Paris Agreement, and it seeks to take emissions back to a level where they are only 1.5 degree more than the pre-industrial levels. So in that direction, various steps have been taken, and this is also one of them. Emissions trading has come into existence. The idea is that if you pollute, then you pay for it. So what is the incentive? You will go for cleaner technologies. So how does the system work? The system works like the industry that pollutes will purchase the permits. The permits will be like 1 kg, 1 permit. So if you have a total emission, say, of 200 tons, then you can see how many, that is 200,000 kgs straight away. So that is at the industrial level. I mean, that is at the industry level. That is not at the level of the units, specific units in the industry. That is all the firms taken together, those statistics are mentioned. So you purchase the permits, and based on the monitoring, you see, you purchase self-monitoring, you purchase the permit, and then if you have excess emissions, then you purchase the permit for the excess emissions. If you have something like 100 and you end up doing 50 kg more, then you have 50 kg of 50 permits more, and 50 permits more means anywhere between 5 to 100, and the system works on a monthly or 1.5 monthly basis. So that is an additional cost which can suck up your profits. So the businesses, in order to avoid this cost, will be anxious to install clean technologies, to make more investment and acquire plants and machineries which have lower emissions, which have better fuel utilization capabilities. And the system was launched as a pilot project in Surat, and they found that the system that worked the system pretty well, and they started with the free permits, 80% free permits, and then reduced the number of free permits gradually. And they found overall the article says that the system is designed okay, but the key lies in the monitoring. If the monitoring is loose and lax, if the permits are allowed to be issued, free permits, if large number of free permits are allowed to be issued, then this defeats the objectives of the policy. Lobbying can also be harmful if the goal of the lobbying is to neutralize the benefits of the new system by diluting the requirement for permits. So this is what these are the major points in this article. Now let us take up the questions. So monitoring is a problem. The author also says this. And if nighttime monitoring is lax and they shift their activity to nighttime, and then they can escape getting detected. So that becomes that will weaken the argument that the ETS system has worked well, right? Come to the choice. Most plants complied with emission norms and reduced their permit usage through advanced technology. This is going to strengthen the author's argument or weaken the author's argument? This is going to strengthen the author's argument. This will not weaken the author's argument. The author's argument is the plants were found to be plants which are falling within the ambit of ETS, emission trading system, were found to be less polluting. That is what he said. So the system is working. But here he says most plants complied with norms. If plants complied with norms, then it only goes to strengthen the author's argument, does not weaken the author's argument, right? Then in the trading prices remain blocked within 5 to 10 bracket across all cycles. And if trading prices remained within 5 to 10, within 5 to 100 bracket across all cycles, this seems to be tangential to the author's argument. Other industrial clusters without ETS also showed similar reductions. Yes, if this one if this during the same period the emissions come down for others also which are not without VDS, then definitely it is going to say something adverse on the effect of the ETS system, right? Effectiveness of the system. This also A and D seem to be the correct option, but A directly undermines the effectiveness of the ETS system if it can be manipulated like that, right? D also, yes, this undermines the argument that it is effective in reducing pollution, because if there were similar reductions which were taking place without ETS, then it means something else is at play, and it is the reduction in emissions noticed in the plants under ETS may not be attributable to the ETS, but to something else. But here, ETS was effective in reducing pollution, weakens the argument. The lack of monitoring weakens this argument more effectively, though D is also a consideration, right? A applies more directly to the POC. Please come to question number 24. So this article is basically in the current economic situation which is prevailing in the world. The author raises a question and answers it. The author seems to build an argument that the WTO has become defunct. The reason is that the WTO had three functions. One is the policy formulation, that is providing a platform for negotiations between the nations. Since the Doha round in 2001, the negotiations have not taken place. So that policy, WTO being a platform for the world leaders to come together and formulate the international trade policy, that function is over. Second function is the WTO has the dispute resolution mechanism. When you have an international agreement, there are bound to be conflicting interpretations of the text of the WTO based on the interests of the specific countries, the conflicting sides. Therefore, you should have an effective dispute resolution mechanism. Now, the dispute resolution mechanism is not effective because some of the larger members of the WTO have blocked appointments to the appellate body of WTO. So the dispute settlement system is also paralyzed. So international disputes, there is no forum to resolve the international disputes within the WTO. And the third is trade monitoring feature. You keep monitoring trade. If it does not facilitate the trade, then it's useless, more or less useless. Then there are inadequacies of the WTO also. Inadequacies that it was not envisaged that the WTO will not have a solution for a problem, the challenge created by China, by the rise of China. The Chinese have not violated any WTO agreement, but the Chinese have effectively undermined the system while taking advantage of it. The Chinese have flooded the world with the excess industrial capacity and excess export capacity and manufacturing capacity that they have. And thereby it is dominating the WTO. But at the same time, it undermines the WTO. It technically complies with all the rules, but flouts the spirit behind the rules. So that is a situation which the WTO has not been able to handle. And the member countries also have their own set of interests. For example, agriculture is a very politically sensitive issue in India, and India has effectively blocked all the proposals on market access in WTO and other provisions. So the the another issue is with respect to the how the decisions are arrived at, the policy formulation function itself. It is based on consensus, and consensus building is basically done in the backdrop of national interests. And there are so many divergent interests that it becomes sometimes very difficult for the political leaders to basically arrive at a consensus. So that has also undermined the WTO. These are the principal arguments that the author builds in this passage. Now, having discussed the principal arguments, let us go to the questions. Yes, please take up question number 26. Oh, yes, you're right. And rest of the choices basically strengthen the author's argument. They don't weaken the author's argument. WTO uh, has not updated. This goes to strengthen the author's argument that it is irrelevant. See, the US continues to impose tariffs. This also goes to strengthen that it has become irrelevant. Major economies increasingly prefer, when you prefer bilateral trade, when you have so many FTAs coming up, then you are basically strengthening the author's argument that the WTO has become irrelevant. So B, C, D are basically strengthening the author's argument, whereas A is effectively undermining the author's argument. Shall we? Let us go to the next 27. Based on author's arguments, which of the following would most likely resolve the deadlock on WTO's decision making? So, decision making is under question. So, what is the stumbling block of decision making? Let the procedure of consensus. Consensus is very difficult to arrive at. If you have a decision making procedure based on the majority, then it can become a little more flexible. And if you have in the majority rule also, you can have something like 50% plus one, or you can have something like two-third majority, or you can have three-fourth majority, depending on how wide, wide, depending on the width of the agreement you want to have. The wider the agreement or the wider the concession, the better the credibility and better the compliance, right? चलिए आगे 27, 28. 28 is correct, so we need not bother about it. 29 is also correct, and I'm happy 30 is also correct. So let us come to the next passage. This article basically talks about the what the author calls as a situation of being between Skyla and Charybdis, or between devil and the deep sea, right? Because the article in the article, the author raises a very important question, and he says that India relies heavily on the US and for its imports, but the US need not heavily rely on Indian imports, because those can be sourced from other locations also, other countries also. Likewise, India is flooded with Chinese goods, so much so that they have a trade surplus which runs into more than $100 billion. So, and whereas our imports or our exports to the China are just a fraction of that, just $14 billion or something like that. The statistics are given. So India seeks to neutralize the trade deficit, massive trade deficit it has with China, by having a trade surplus with the United States. But now with President Trump's policies, economic policies, which are not new, which have a continuity in them, President Joe Biden, the predecessor of the current president, also continued the same policies. And these policies basically may end up sucking up the entire trade surplus that we have with the United States, and we'll be left with nothing but trade deficit with China. So the author seeks to uh, seeks to reason out as to how we can tackle this problem and what we can do about it. The author uh, uh, the author basically says that code is what we can do about it. The author doesn't have much of a solution to offer. In the code grouping, also the author points out that there is a problem because it may be seen by China as hostile to it, and this may create a problem for India because India don't want to antagonize. India doesn't want to antagonize China over the quad grouping because the author seems to have this in the mindset that ultimately it is the Russia and the Ukraine which are fighting with each other. Nobody else seems to have joined except for some countries like North Korea. Nobody that has become a localized dispute between the two warring nations. That would also happen in case of India and Pakistan, India and China, if it comes to that. And that is a situation that nobody would be happy with because that situation would be heavily loaded against India. So these are the problems that the author identifies. But the author doesn't have any coherent solution for any of these problems. Probably the solution is obvious that India, in one of the previous articles we have studied, that India has seen too much of comfort and India has not pushed ahead with the reforms. India missed the opportunity to become a production base for the world. The opportunity was taken over by China. The opportunity was taken over by Southeast Asian nations such as Malaysia, Vietnam, and others. So India, the if we generalize the if we import the learnings from other articles, then basically we should focus more on manufacturing and try to neutralize our heavy trade deficits by strengthening our manufacturing sector. Right. Now let us come to the questions. Yeah, first 31st is correct. So second also correct, third also correct, fourth also correct, fifth also correct. Very nice. Come to the I think this is the last article for the day. Come to this article, please. Next article. Pathogen Access Benefit Sharing System. Please start. Shook up the world community to the need for global cooperation in development of vaccines because one of the forecasts uh, in regard to the environmental instability that we are presently focusing is that droughts will come with increased frequency. Natural disasters will strike with more fury. They will become more furious. The pandemics, the pandemics used to occur at a gap of nearly a century. They will become very, very frequent, and we have many pandemics already on the hand, and one of some of them are stated in the article also, and those are bird flu and pox, measles, Ebola, and so on and so forth. So uh, these problems have forced the nations, and also the problems that came up in the wake of COVID-19 pandemic. Basically, the problem was that the COVID-19 very clearly threw up uh, the debate between the divergence between the global north and global south. It brought out the divergence very clearly. The rich countries were able to have the testing kits, were able to have stockpile the vaccines and so on. But the poor countries were left to fend for themselves. And it's heartening to note that we have read in previous articles that India had, on the positive side, India undertook vaccine diplomacy and became a pharmacy for the world and supplied its good quality vaccines to many nations. whereas other countries also tried to mimic what India had done. And in some instances, the vaccines by other countries were found to be defective. But the point is that this vaccine nationalism uh, created a lot of problem for the resource deprived global south. So this in this backdrop, the and in the backdrop of increased frequency of the pandemics and the increased frequency of other disasters, the world leaders have come together and negotiated what is held as a um, very great agreement. And the salient features of which are basically the way it has been negotiated also shows the kind of divide that is there between the north and the south. Whereas the south wants access, the north wants profits. They say that our vaccines, our medicines are basically uh, very expensive because manufacturing them is very expensive, research is very expensive. So we can't make them free of cost for anyone. We will require, before you have a system of compulsory licensing of uh, the patents which have been taken and allowing other countries to exploit the patents, you have to give us a guarantee the for the respect of our intellectual property, that the they will not be shortchanged. That they take away the technology, they take away the the patented information, and they start manufacturing themselves, and we are left high and dry. We don't get our returns. So that kind of concern has also been voiced, and finally the agreement could be reached only when they reached a consensus or on the text of the treaty, which basically balances the two concerns of access for the global south and protection of intellectual property for the global north. And the agreement, uh, how the of course we are in the international realm, how the agreement is going to be enforced if suppose some country does not comply with the provisions of the treaty, then of course this is an international system in which all states are sovereign, and there are limited it is not like we have a centralized machinery for addressing all those issues. That does not exist. Therefore that limitation is always there in almost every agreement, however well drafted it may be on the international sphere. Now let us please come to the questions. Question number 36. The first one, basically, most pharmaceutical companies already share pathogen, which does not weaken the organ. This only strengthens the organ. Right? We have to see the weakens. In some countries, delay sharing pathogen data. That also does not strengthen the organ. There is no effective access. There is no effective benefit sharing. There is no effective mechanism to prevent vaccine nationalism. This is exactly what it says. So, does not have the power to enforce PABS. This weakens the argument because there is no central enforcement mechanism for any international agreement. Then the agreement includes a clause for, though there is a provision in the UN Charter, right? I think it is Article 51, where the Security Council has the this thing, but then Security Council is mired with the disagreements, the veto system. So effectively, there is no international system of enforcement. Then the agreement includes a clause for mutual agreement in technology transfer. Mutual agreement in technology transfer does not seem to weaken the effectiveness of the pathogen access benefit sharing system. It only accommodates the concerns of the rich nations. Please come to the next question, 47. Based on the passage, which of the following is the author most likely to agree with? Mandatory technology transfers are essential for equitable pandemic response. Author won't agree to this because there is a consensus on technology transfer and the fair access. Intellectual property rights must be upheld even during global health crisis. Now, this is not what they seem to say. This is on mutual basis, mutually agreed terms. This is what the article says. Equity in access must be balanced with innovation incentives. That is what the author talks about. equitable access, and at the same time intellectual protection. Low-income countries should develop their own vaccines. This is essential. Please come to the next question. 38. Based on authors' arguments, which of the following, if true, would help resolve the lack of equitable vaccine access seen during COVID-19? So, lack of equitable access, which is going to help high-income countries pledge to donate leftover vaccines. This is not what the article says. A binding clause mandates minimum vaccine reserves for export during global emergencies. This effectively counters the nationalism. They say that have a certain percentage for export. So this effectively counters that. Pharmaceutical companies voluntarily agree to lower vaccine prices during pandemic. It's not about prices. It is about availability. It is not there. What price will do? WHO sets up a global digital platform to track vaccine stockpiles. This also seems to make sense. But then it says that WTO should track who is stocking. How will that help? Suppose XYZ is stocking. What WTO will be able to do by tracking? Nothing. But then if you have a binding clause mandating minimum vaccine reserves, this can surely do. But then suppose the binding reserve is not heeded to by the country, then there is a centralized problem. There is lack of enforcement. This is correct. Please come to 40. If the final agreement had included a mandatory technology sharing clause instead of mutually agreed terms, which of the following outcomes is the most likely to? So he's saying, had there been something like technology sharing is mandatory without having concern for the intellectual property interests of the rich nations, then what is the what is the outcome? That there will be a breakdown in negotiations straight away. B. Rapid technology diffusion, no question. They will not give their technology. What will you diffuse? Increase support from farmers. No, so pharmaceuticals are opposing. Complete shift away. No, nobody is giving up intellectual property rights. That finishes our article 72. Tomorrow we will take up 73. Within a few days, we should be able to upgrade ourselves to completing one article per day. I mean, one test paper per day. That would be just fantastic. But then that may require a slightly longer sitting. And maybe we can have 2 sittings instead of 1, if that is feasible. All right, beta, come prepared tomorrow with Article 73rd mock paper. Legal reasoning, 4 questions you prepare. If you can do the logical reasoning also, so much the better. Right, bye-bye.
The lecture series revolves around discussion of mock papers. You can request us for the concerned mock papers. If you intend to join us in our daily discussions, you are most welcome.